Hi, and welcome. I'm Lisa Lightner from adayinourshoes.com. And, hi, I want to thank Vicki and Disability Pride Philadelphia for giving me this opportunity. My sons and I have been participating in Disability Pride events in Philadelphia since the very first one, as Vicki and I were just discussing. For the past decade or so, I have been working as a special education advocate, and that is I assist parents through the IEP process. I live out here in Chester County, so I don't know the demographics or locations of where you all are from, and that's okay if you want to say hi and tell us where you're from. But I just want you to know that for the purpose of today's presentation, I'm going to be talking about pretty much Pennsylvania specific things, since this is Disability Pride Philadelphia. So I'm going to move into screen share so we can see my presentation. Here we go. And present. Whoops, hold on. Present. There we go. Okay. What I thought I would talk about today is parents' rights and IEPs, and your parents' rights are your procedural safeguards booklet. And the reason I chose this topic is, first of all, I could talk about IEPs all day, and sometimes I do, but I wanted to give you something that was kind of a foundation of all the other IEP topics, if you will, especially given what's going on right now with COVID and people having to do distance learning and all the uncertainties. I thought that this is knowledge that you can use anytime. It will not ever be valid. Whereas if I talked about COVID, I mean, who knows, this might clear up in 2 or 3 months and things will be back to normal. So anyway, that's what I'm going to talk about today. Also, I find that a lot of parents, they know that they have some rights in the IEP process, but they don't always understand what they are or where to find them. So I wanted to point that out to you. Okay. So parents' rights in the IEP process come in a booklet called Procedural Safeguards. And I don't like that name, Procedural Safeguards. I don't know, there's a lot of legalese in IEPs, and it's kind of intimidating, I think. Procedural safeguards, it's not something that rolls off the tongue, but basically it is your parents' rights booklet. Some quick facts about them. These are the booklets that should be provided to you annually. IDEA says that you are provided with this book, that your school needs to provide you with a copy of yours, and they in fact make you sign a sheet that says that you have been provided these booklets. Unfortunately, what I find is that a lot of parents sign the sheet, saying that they have received it, and then they go home and they toss it on a pile and never read it. So we're going to go over some of that today. Another thing about procedural safeguards that parents don't always know is that the regulations are very specific, and that these need to be in a language, they must be in a language that you can readily understand. That doesn't mean if you are bilingual and you are comfortable with English, you do not have to request, a different copy of procedural safeguards, but you can. And from the trainings that I've been to from the state of Pennsylvania, this is something that the state is very much encouraging right now for school districts to provide this. And that doesn't necessarily, just mean Spanish. It can mean Mandarin or Vietnamese or Farsi or whatever your native language is. If you need them in a different language, you are entitled to receive them in a different language. A couple of other little issues that I've seen with procedural safeguards is that, of course, since it's a booklet and schools have to make their own copies of them and hand them out to so many parents every year, sometimes little things get kind of overlooked. One is that you want to check that you have the correct number of pages, and particularly look at front and back. I've often seen procedural safeguards booklets that were intended to be two-sided, but they were only one-sided. And if you looked at them, you only had the odd number of pages. Therefore, the parents would be missing essentially half of the information, or just missing pages. You just want to make sure that it's complete, particularly if you are going to take the time to read them. They are state specific. The U.S. Department of Education does host a copy of procedural safeguards on the federal site. However, each state has its own little nuances when it comes to special education laws. And a state can do more than what the federal government says, but they cannot do less than what the federal IDEA regulations say. So in some states have shortened the evaluation timelines. Some states like ours, Pennsylvania, has a much different discipline requirement or non-requirement, or discipline protections, I guess is what I should say, for those who are intellectually disabled. So if you are going to look for a copy and you want a solid copy that's going to be complete, you can just, go to Google and put in special education IEP procedural safeguards, Pennsylvania, New Jersey, wherever your state is, and you will get the correct copy, and it should be on your state's website. Okay, this booklet will outline your rights as well as the dispute process for if you have a disagreement with your school. IDEA and state regs have a very well-defined dispute process for those who disagree with their school district. Okay. As I said, I could talk about IEPs all day, but since I don't have all day, I wanted to highlight some of the most important points and some of the most rights that parents have that are misunderstood. There's a lot of whisper down the alley and miscommunication between parents and school, and what's out there may not be true, and so on. So I want to talk about the PWN today, which if in Pennsylvania, we call it a NORP. I'm going to talk about evaluations and independent evals, parent participation, complaints, and your dispute process, and as well as pendency and stay put. Okay, prior written notice, which in Pennsylvania, our sheet says at the top of it, PWN prior written notice, and then we have a slash, and then it says NORP, which stands for Notice of Recommended Educational Placement. Again, it's one of those state-specific things. As far as I know, we're the only state that calls it this. I don't know why we do, but we do. But if someone is talking about a NORP, they are also talking about PWN. And I just want to switch for a minute, since I'm sharing my screen, as far as how important this is. Now this is, can everybody see that? If they could nod. This is a copy of the Pennsylvania procedural safeguards. I just went online and got them a couple days ago to make sure I had the most recent copy. And prior written notice, I mean, it's really, as you can see here, it's letter B. It's the second one. That's how important it is. After it gives you the definition of what is a parent or who is a parent in the IEP process, prior written notice is the second one. So it's, I mean, I can't, this is like just something I'm completely passionate about, because when you understand what prior written notice is and you use it in the process, it can be a very powerful tool to be heard and to have your child's needs met. So first, I want to clarify, a lot of parents misuse or misunderstand how the word prior is used in prior written notice. So they're not required, and by they, I mean the school district, your IEP team. The school district is required to give you prior written notice, and prior means prior to the action being taken. They are not required to give you this notice prior to an IEP meeting. And that's where a lot of the confusion lies. They can present you the information at the IEP meeting, and that can be the first time you hear this proposal or refusal, but they cannot implement it without giving you this in writing. Okay, so to start to explain it better, here are the 6 instances or 6 conditions when it is required. So if your school district is proposing to initiate or change the identification, evaluation, educational placement, or the provision of FAPE to your child. So what that means is they cannot change your child's placement without giving you written notice, or change the provision of FAPE. So basically they cannot change an IEP without giving you written notice first. Okay, this is huge. The same goes for change of placement for disciplinary reasons. They have to give you prior written notice before they make that change. If they're going to do a due process hearing, again, they have to give you prior written notice. And we're going to get into what exactly that looks like in a minute. If they refuse, if you've asked for an independent education evaluation or an IEE, which I'm going to get into those in a little bit more detail in the next slide. But again, they have to give you prior written notice. Okay, and same if you want to revoke your consent to special education, they have to give you prior written notice. So here's what prior written notice has to look like. And what they look like from district to district may be different. Sometimes districts use a software called IEP Writer. Sometimes they make up their own forms. As long as it contains the necessary information, there is no right or wrong form for this. So your prior written notice, and again, in Pennsylvania, it says so right across the top what it is. It describes the action that your LEA proposes or refuses to take. This is big, refuses to take. If you've requested in writing that your child receive, more therapy, a different placement, a one-on-one aide or a paraprofessional or an interpreter or a piece of assistive technology that you've asked for. If you've requested that in writing and discussed it at the meeting, if they're not going to do that, they have to give you a prior written notice form detailing why. And this is why prior written notice is so huge, because what I find after attending, hundreds of IEP meetings over the past 10 years, what I find is that in a meeting, it's very easy to say no. It's actually really easy to say no to your face, because it doesn't often come across as just, no, we're not going to do that. It's going to be well, let's wait and see. Let's give it a few months, see how he does. Okay. And, wait and see means never, right? So that's why this is huge. If you've asked for this, I find it's much more difficult for them to document it on the official form, because they have to explain, see number 3 here? They have to explain why they are refusing to take this action. And then they have to describe what evaluation procedures, assessments, records, or reports that they used in deciding to refuse this action. Okay, same goes for the placement. So if you are asking for a more restrictive placement, or maybe they're trying to place your child in a more restrictive placement, and you're not for that, they have to explain why. How did they get there? Okay, you can't just come in one day and say, we're going to send your kid to a special school, see ya, and off he goes. If they're going to propose to change the placement, before they change that placement, prior to changing the placement, they have to give you this written notice that explains exactly what they're proposing and the decision-making process that they used to get there. Okay. So in addition to, to providing you all of this, they have to, once again, give you your procedural safeguards so that you understand the dispute process and include resources for you to better understand this. Okay. Also here, I'm going to make this one a little bit bigger. Oh, come on. Whoops. Share screen. Sorry. Here we go. Okay. Number 8 is describe any other choices that your child's IEP team considered and the reasons why those choices were rejected. So if you asked for a different placement, or they're trying to place your child in a different placement against your wishes, they have to, on this prior written notice form, they have to describe what else was considered and why those choices were rejected. So let's say, they're trying to place your child in a more restrictive school for behaviors. Have they considered a one-on-one paraprofessional for a behavior? What least restrictive environment considerations were considered before jumping to a more restrictive placement? Okay, that's why this is so big. And again, it's the second one in there. It has to be, your PWN also has to be in your native language, or language. It doesn't have to be in your native language if you're comfortable with English. But if you are not comfortable and you want it in a language that you can readily read and understand. Okay. So again, that's why this is so big. Let me make that smaller and go back to this. Because again, what I find is that it's really easy to tell someone no in a meeting, or it's really easy to kind of put parents off and say, oh, let's just wait and see. Let's just wait and see how he does. And they just put you off for another 6 months, 12 months, and it never happens. They're required to provide this to you, what you ask for or what you're not in agreement with. They're required to provide this to you in writing. So how do you use it? If you want something, you ask for it, and make sure you ask for it in writing. I believe that my son would benefit from a one-to-one paraprofessional. I believe that my son needs this to access his education. You want to put that request in writing, request an IEP team meeting to discuss it, and then you follow up with the team's decision. Say, I expect to receive this on a PWN or a NORP. Because again, it's just much easier for them to say, let's wait and see, or no. It's much more difficult for them to document it officially on these NORPs, because that adds to your paper trail that you need if your child further regresses or behaviors increase, falling further and further behind in reading ability or whatever your concern is. You're going to have this documentation that you asked for such and such service or support 6 months ago. Okay. Another important thing, and this is a weird Pennsylvania thing, and I hate it, but it is what it is, as they say. The NORP has a 10-day limit. And what that means is when you get your NORP at the end, it lists all this stuff that I just went over. And then you have these boxes and that you say, I agree, I disagree, and I'm going to file for due process, or I disagree, I want to have another meeting. There's 4 or 5 different options on it. But when parents disagree with things, and I understand, I truly understand how in the IEP process, when parents don't feel powerful and they feel like withholding their signature is a power move, and they say, well, I don't agree with that, so I'm not going to sign it. The thing is, in Pennsylvania, if you don't agree and you don't sign it, it automatically goes into effect in 10 days. So if you do not sign it within 10 days, it goes into effect. I don't necessarily think that's fair. I think 10 days is a really short time frame. But again, once you receive your NORUP, I would email your team leader that day and say, I received my NORUP today, because there's a lot of arguments, and this is one of those things that teachers say one thing and parents hear from other parents that it's another, about if it's the date of the NORUP. Is it 10 days from the IEP meeting? Is it 10 days from the date of the NORUP? It's 10 days from the day you receive the NORUP, and things do get caught up in mail rooms, and there's holidays and things like that. So when the day that you receive it, you want to send them a quick email. Hey, I received my NORUP today. Today is July 8th, right? I'm going to be taking my 10 full days, and I will get it back to you by then, or something like that, just so that you can confirm with them that you've received it. You're going to take your full 10 days so that they don't automatically implement something. And it also lists all your alternatives there, and to your different options on the NORUP. Okay. 1, 2, I'm already like running out of time, I feel like. I wanted to get into, also listed in procedural safeguards is things about evaluations and IEE, which stands for Independent Education Evaluation. It lists there for you the timelines for evaluations. Some common issues that I see with parents and misunderstanding independent evals, and I put it here as the clause no one reads, and I want to show you that clause. Parental consent. Hold on. See, then this is a 35-page booklet, and so I didn't want to. Sorry about that. What the point I want to make here is that parents mistakenly hear from other parents that you have the right to get an IEE. And so many parents are confused and don't understand and blindsided, because you don't have the right to an IEE, you have the right to ask for one. And that's a big difference. Okay, not everybody who asks for an IEE from their school is approved. And so again, you don't have the right to receive one. You have the right to request one. So the clause that no one reads and it's very specific in procedural safeguards, that there are certain circumstances, and that's when you disagree with the school's evaluation, if the school has refused to evaluate your child, if you are questioning the evaluator's credentials or qualifications to do that evaluation. And there's other things such as testing criteria and testing protocols. So if they give your child a test that's very reading and language intensive, and your child cannot read well, that's not a very good, say, IQ test for them to take, because their reading ability might be the issue, not their intelligence, and so on. Okay, so that's just some of the criteria. Sorry, I'm going out of order a little bit. That's just some of the criteria. And again, it's all listed in your procedural safeguards as to when you can request an IEE. Another misunderstood point about IEEs is that IDEA and the PA regs are very specific in that they say the school district must consider the information presented to them in an IEE report. That's it. Even if they agree to pay for it and agree to get your child this IEE, they do not have to follow every recommendation to the letter. So a lot of parents think that this is a slam dunk. Oh, I'll just go out and get an IEE, and that'll show them what my kid needs. And that's not the case. They only have to consider the information. Now, should you end up in a further dispute, having this report is going to make your due process case stronger. And it's going to, if you're arguing with your school over supports and services, this is going to support your cause. But again, they still only have to consider the information. Some other common issues that I just see is that independent evaluator is just that, independent. The school district is, I believe, required to provide you a list of evaluators, but you do not have to use their list of evaluators. They cannot, I don't believe that any courts have upheld a price limit. That comes up a lot, like, yeah, we'll pay for an IEE, but we're only paying $1,500. And most of them are much more than that. And again, you do not have to pick from their list. And that's one that gets, again, it's all these like urban legends or whisper down the alley that happens. And it's not true. You do not have to pick from their list. In fact, I wouldn't, I work as an advocate, so I'm always advocating for advocates as well, but advocates know which independent evaluators are kind of in the district's pocket, as they say, and which ones are more parent friendly. And I certainly wouldn't pick someone who repeatedly goes to due process hearings on the side of the district, but that's just my personal opinion. Okay. Parent participation. There's a couple of things that are defined in procedural safeguards as pertains to parent participation, and there are some things that it does not define. It defines, who they consider a parent. It also defines educational surrogacy. Some parents may be incarcerated, they may be deployed. There's a lot of different reasons why a parent is not able to participate in the IEP process. And if that is the case, an educational surrogate can be found. But what it does not define, and it never will, is divorce and custody issues. And this is another common question I get from a lot of different parents, that, mom doesn't like the new girlfriend, or mom and dad are not on the best of terms. And sometimes, we know this happens in divorce, that parents use kids as a tool to kind of power struggles, divorce. It's divorce. What are you going to say? It's like that sometimes. But your IEP team will not and should not be expected to ever participate in kind of mediating any kind of divorce and custody issues. You're not going to find it in IDEA. You're not going to find it in state regs. If the parent is a parent by definition and are entitled to go to IEP meetings, they are entitled to invite who they wish. And if that's a second wife or a second husband or girlfriend, boyfriend, mother-in-law, former mother-in-law who maybe you didn't get along with so well, they are entitled to invite whoever they want. And the district cannot and will not uninvite someone who's been invited by the parent, the exception being an attorney in Pennsylvania. But anyone that a parent wants to bring to a meeting, they can bring to a meeting. So this is the type of thing, if you are in a divorce and custody situation, you want this spelled out in custody arrangements, particularly, if you have restraining orders and things like that. It needs to be spelled out in your divorce and custody arrangement who has issues. So, okay, I have almost 12:30. So are there any questions so far before I move on? Sorry, let me look in the chat. Oh, stop sharing. Let me go to the chat quick and take a look. Nothing yet, okay. Okay, if you do have questions, feel free to put them in the chat, and I think Vicky is going to pass them along to me. If not, I'm going to go back. Sorry, I talk really fast and I'm trying to get through all this. Okay, so divorce and custody, fun stuff, isn't it? Okay, IEP dispute resolution. This is outlined in procedural safeguards. In Pennsylvania, this is the website you want to know. It's Office of Dispute Resolution, PA. They have a ton of information and video series, and they have mock meetings and all kinds of fun stuff. I guess if you're an IEP nerd like me, but there's lots of great information there if you're trying to navigate this process. I just wanted to go over a few of the options. One is a facilitated IEP meeting. And if your IEP meetings are becoming a little contentious or tense, a facilitator will not mediate. Mediate is kind of like the next level up. These are kind of incremental steps. A facilitator will just facilitate. They'll keep everyone kind of civil, keep everyone on task and on topic, but they will just facilitate the meeting, which is different from mediation. A mediator is really trained in just that, mediation, and their goal, although it doesn't always happen, most of the time is that they say at the end of this mediation, they want you to have a written agreement in hand. And the mediation sessions that I've attended with clients, they do tell you to set aside your entire day. You can bring in expert witnesses if you want, if you did have an IEE and you want that person to come with you. But they, at the end of the day, their goal and their job is to mediate so that you and the district can come to some agreement. They sit there and they type it up as you go through the process if you are coming to an agreement, and it is a legally binding agreement. Okay. And then of course there's due process, and that's another one. Like, you hear those words due process and I don't like them, and people say, well, I'm going to sue the school. Okay, it's kind of like that. It's an administrative hearing. There is a hearing officer. You have to file for due process. You have to prepare a due process complaint when you submit it. And in Pennsylvania, I would say, first of all, let me tell you that nationally, you can represent yourself in due process and do it without a lawyer. The district will never go in without a lawyer, so I don't think that you should either. That being said, I do know a few parents who have done this successfully, but the success rate for parents prevailing in due process is in the single digits as far as percentages. It's very few parents, and it's not because your case, or that you weren't right or that you weren't correct. It's that you didn't present a good case. As I said, the district will always have an attorney, and they will always provide expert witnesses. And they're just much more savvy in this than the average parent. And the average parent, who loses, to the tune of more than 90% each year, the parent who loses, again, it's not because your child wasn't deserving of what you were asking for. It's usually because your case wasn't strong enough. And that is one of the downfalls of due process, is that once you get to due process, it's not really about the child anymore. It's about who has the stronger case. This is a legal administrative hearing, and it's, you know, the hearing officer has to go by what data and what evidence they've been presented. And parents just aren't, you're just not as savvy as lawyers because you're not lawyers. You might be an expert in your child, but you're not an expert in how to prepare a solid due process case. We do have here in Philadelphia some great law firms who do take pro bono cases, such as the Ed Law Center and the Public Interest Law Center and a few others. So, and you know, there's help out there. So I would always go to one of them for assistance if money is an issue. But that being said, also in Pennsylvania, more than 90% of the due process cases that are filed never actually go to due process. Most end up in some type of settlement. And that is kind of like the positive in all this. Whereas you think like, oh, I'm going to have to hire a lawyer and do all this other stuff. There's a greater than 90% chance that it's going to settle, in which case your legal expenses will not be as expensive as you thought. And in settlement agreements, almost all the time, the lawyer's fees are wrapped into the settlement agreement. Okay, so that the district will cover your legal fees. So this is why I you know, there's so many great law firms in this area, not just the you know, civil rights ones that I kind of mentioned, but there are a lot of private special ed attorneys for families within the Metro Philly area. And most of them do a free consult. So it's always worth it to at least go do a free consult rather than to just say, well, I know I can't afford an attorney. You just don't know. And you know, if it's your child's future and your child's education, you want to explore all the options. Okay. But all of this stuff, all the dispute resolution is outlined in procedural safeguards. Okay. So I shouldn't have done this one last because this is the one where I tend to get the most questions. And that is on discipline. So in 5 minutes or less, let me try to go over discipline. Children with disabilities and children who have IEPs are entitled to more considerations when it comes to discipline procedures. So let me just open up those procedural safeguards again. Due process. Oh, state complaints. I'm sorry. The state complaints, that's also in there. So maybe you don't want to file for due process, but you want to file a state complaint. That's in there as well. Due process, impartial due process hearing, hearing officer, civil actions. I know there's again, it's a 35-page booklet. Mediation. Actually, you know what? Before I get into discipline, because I want to take questions on that if there are any. I did put something on there about stay put, and stay put in pendency. What that means is if you're going to mediation, if you're going to due process, and you're in the throes of that, your child stays put. Everything in the IEP stays put. If you get that PWN and you don't agree with it, and you're going to check this box that I do not agree with this, everything as it is stay put. So that means until the dispute is resolved, your child stays put in everything. And that means if they're trying to change the eligibility category, which that's one that I hear a lot, trying to move kids from autism to emotionally disturbed and learning disability to emotionally disturbed and so on. If you don't agree with that, everything in the IEP stays put until you resolve that dispute. So there, that's okay. Disciplinary stuff. So if you're in Pennsylvania and I'm talking about a disabled child, but I'm not talking about intellectual disability. I'm going to get to that in a minute because it's separate in Pennsylvania. there's this rule of 10 consecutive or 15, where is it? 15 cumulative. Okay. If the LEA, that's your local education agency, that's your school district, they are required to issue you a NORUP prior to the removal that constitutes a change in placement. So a change in placement is for more than 10 consecutive days or 15 cumulative days. Okay, so what this means is you have to have these, what is called a manifestation determination hearing. And again, sorry, I'm trying to be brief, but I still want you to get the information. Because I could talk about discipline and the unfairness of it all day too. But if your child is suspended from school, even once, I would go immediately to your procedural safeguards booklet and start reading up on it, because 2 days here, 3 days there, before you know it, you're at that 15 days. And first of all, we know that suspensions are punitive in nature anyway. They're not restorative. They don't help the child. They are merely punitive. And all they do is cause a disabled child to fall further behind because they're missing school, and it rewards negative behavior. Chances are the child doesn't like school anyway, and now you've just rewarded them by allowing them to stay at home. But it outlines everything as far as getting a functional behavior assessment, a behavior plan, and again, you have to read up on manifestation hearings if you want to demonstrate that this behavior was a manifestation of their disability, such as ADHD. One of the hallmarks of ADHD is impulsive behavior. One of the hallmarks of autism is, I've seen kids get suspended for Tourette's tics and cursing. I mean, stuff like that just makes no sense at all. So you want to make sure that you are familiar with the disciplinary procedures for children with an IEP. Now, what's different in Pennsylvania is that if the child has an intellectual disability, you cannot even suspend them, not even for 1 day, without a PWN. Okay, again, this is intellectually disabled only, but you cannot even suspend them for 1 day without providing the parent a PWN. Also, what happens a lot is kids have a bad day at school, they do something, they don't do something, whatever, and I mean task refusal, and they call the parents to come pick them up. Can you come get him? He's having a bad day. Can you come get him? He just had an outburst. Those are considered suspensions. Just because they don't use the word suspension, just because they didn't issue you a PWN, does not mean that it wasn't a suspension. Your child was asked to leave school and his peers were not. That's a suspension. So my tip to parents is always, when you go to pick up your child, you can refuse to pick them up. That's, as a parent, you have to go with your gut on what you think is the right course of action. But if you pick them up, when you go in the office and you sign them out, as most schools require you do, put it in the book. Reason for leaving: you were asked to come pick them up, and start documenting this, because what we're just finding a lot of, as budgets get tighter and things like that, that we're seeing a lot of reactionary techniques rather than restorative. And again, you've just taught the child that if you're having a bad day and you're not enjoying yourself at school, rather than teaching the child coping mechanisms, you've taught them that, hey, you can act out and then you get to go home. There are special circumstances. So weapons is one, and you want to be very clear on what is, definition of weapons. Read your school district policy as well. There's been a lot of attention focused on this. Certainly prior to COVID, there was. Now that kids aren't actually in school, it's died down a little bit, but we've seen kids suspended for things like making a finger gun. There was a very famous case in Maryland a couple of years ago where a 7-year-old with autism, he chewed his Pop-Tart into the shape of a gun. And because the district had a zero tolerance policy, that was considered a weapon. So you want to be very clear on what your school's definition of a weapon is. Illegal drugs, serious bodily injury. And I have talked to several folks who say, serious bodily injury has to be, it has to be serious. And it defines drugs and all that other fun stuff. So let me go back. So again, the timelines are without intellectual disability, it's more than 10 days consecutive, 15 days cumulative suspension. Anything more than that constitutes a change in placement. And again, for intellectual disability, it's even 1 day. There is an appeals procedure. That's also listed in procedural safeguards, how to appeal these decisions. And then the exceptions, we talked about bodily harm, weapons, drugs. Okay, so that's all I have one more slide after this, but I strongly encourage you, if you haven't read them, you should read them. Read them at least once a year. If it makes you feel better to say, I don't have time, and it's not light reading, it's not fun reading, it's not beach reading. Put them in your bathroom, something like that, or put them in your handbag. And when you're at appointments or waiting or stuck in traffic, you can read them. It will increase your confidence. I find, as we always say, knowledge is power, and it's going to increase your confidence to kind of know what rights you have. Most IEP team knowledge, I've learned over the years, there's a huge disconnect between what folks are taught in school, if they're a special ed major, and what really happens in classrooms and school buildings. And most IEP teams are not malicious. It's just become a game of kind of whisper down the alley, and this is how we've always done it. And in day-to-day practice, what teams learn is they learn from the people who have been in the building longer than they have. And they've been in, they learn from their administrators. And it's often incorrect information, but again, it's not necessarily always malicious. It's just this is just what we do here. I've just, like I said, I've attended hundreds of IEP meetings over the years. And just some of the things I hear, like, well, the teacher said this, and it's blatantly wrong. But that's why it's just all the more important for you to know what is correct. The team isn't always correct. And again, it's not always malicious. There have been times when I've sat in manifestation hearings, having done my homework, and I literally went out into the parking lot and called an attorney afterward, and because I was just being gaslighted so much. And the attorney said, no, you're right. You're right. But that team was just so adamant that I was incorrect. And anyway, so it happens. There's also there's resources in the back. In Pennsylvania, there's a whole list of the agencies in Pittsburgh, Harrisburg, Philadelphia, where you can get assistance. It defines what is an educational record and what your rights are as far as educational records. And so much more. It's a fascinating book. It really tells you a lot. If you have more questions, call me. No, I didn't even give you my phone number. But you guys should find me. I have a Facebook group associated with my blog where there's a lot of advocates in the group who assist parents with your questions. So feel free. I know Vicki already gave my website. That's my email address. And if you just do a search on that, you'll find a Facebook page and a group. But the group is where we allow parents to ask questions. Speaking of, let me go back to stop screen share. And okay, no questions?
I do not see any questions yet.
Okay.
But this is so eye-opening. for me even, my son received an IEP the second time he went to first grade, because the first time he went to first grade, the teacher told me that he was just too immature, and that he should repeat the grade, to find out that it was not true whatsoever, was amazing. And so he had an IEP, for all of school. And then we actually talked to his college about what that looked like for college, which he unfortunately decided that was just way too much for him.
Yeah.
Happens. But when I the IEP, give you the book. He did go to school in PA. And I thought, well, they're explaining everything, so I don't need to read it.
And that's, and there's nothing wrong with trusting school personnel, but for many parents, well, I'll tell you, and then that's actually exactly, I was already learning to be an advocate when my son was moving from preschool to school age services. I was becoming an advocate, and I thought I was so well prepared, and I went to this IEP meeting and I had my arguments and I had my data and I had done all this stuff. And it really, I always say, most moms come to me with nothing more than a gut feeling that things aren't right. But they don't know how to define it. They don't know where to find help. But that's exactly what happened to me, is that this woman looked at me and she said, I really thank you for all your input today, Mrs. Lightner, but we're not going to be making any changes to this IEP. And in my gut, I just thought, that doesn't sound right. And just pursued it from there. But I understand how and why it's an overwhelming process. I mean, if you read IDEA, I don't even know how long the state regs are, Pennsylvania chapter 14, which is our chapter of regs on special education. I mean, who knows how long that is? It's long. It's not easy reading. It's a lot of legalese. It's a lot of, they just don't write statutes in, the way they do a pop culture novel. Right. So and there's just so much information. Like, even in the booklet, there's a booklet that accompanies IDEA that the folks in DC wrote to kind of further explain IDEA. That's 600 pages of 3-column, like size 2 font.
Oh, I would never be able
I mean, it's and I've just become best friends with my Control F feature so that I can find what I'm looking for in it. But it's such an overwhelming process. And we're 45 years into IDEA. For Pennsylvania, it started in 1971. So we're almost 50 years into it, and it just evolved into this like unmanageable beast for parents. So
definitely.
I think it's, you don't know what you don't know, but I'd say, you got to start somewhere, and reading procedural safeguards and kind of digesting it one concept at a time is a good place to start.
Yeah, I truly believe that. I mean, I was a very young mom. I didn't know, like, the way that they explained it was that what they were telling me was in the booklet. So I didn't look at it until the third year in, when my son got in trouble. And somebody told me, have you read like what they, and I said, no. And they were like, you should read it tonight. And I went through and read it for an entire night. So,
right. Well, and that's what I find is when your child gets suspended from school, it's stressful. You're sometimes embarrassed. You may have gotten called away from work. It's certainly not a happy day. And, you're told, hey, come get your kid. And you know that your child is distressed at school. So you want to help them as well. And I've seen, unfortunately, a lot of school districts stick things under parents' noses. Here, sign this and you can take them home.
Yep.
And parents don't know what they're signing.
Yeah. Yep.
So
That is great.
anyway,
For any parent out there, I think that's the best thing they can do is they need to read. It's not that I don't want people to trust these schools, but you're signing a document saying that you understand, and they
yep,
use that against you when you don't.
yep,
So,
yeah.
but thank you so much for all of this.
Thank you.
I really enjoyed it. This went live over Facebook also, so there are tons of people out there.
Great.
And I did give them your website so that they
Okay.
can contact you. And we will definitely have another session of this in the future. And I want to thank everybody for coming today. I hope you're enjoying Disability Pride Virtual PA. We certainly are. We have some really great things coming up today. And then this weekend is kind of like a star-studded event that is going on, and we just don't want you to miss it. You can go to our website at www.disabilitypridephiladelphia.org. Thank you all.
Thank you.
Thank you to our interpreters and to Janet for captioning. It was an amazing experience.